Any mention?
Yes.
May please, Your Lordship. Your Lordship, I beg to make a mention of item number 7, Your Lordship. I'm praying for 2 weeks' time, Your Lordship, in this matter.
Who's the other side?
I'm for the private respondent number 4 and 5, my lord.
I'm for JTTC.
Nakmaship. Nakma.
Lordship,
no,
it is.
No objection.
No objection.
As requested by the learned counsel of the petitioner, this is matter for 2 weeks. Yes.
Your Lordship, I beg to make a mention of item number 9, 10, and 11 also, Your Lordship. It is a connected matter, Your Lordship.
9 and 11.
9, 10, and 11, Your Lordship.
Yes.
In this matter also, I'm praying for 3 weeks' time, Your Lordship.
You have no objection. Same order. Yes.
Highly obliged.
Please, Lordship. This item number 17, Your Lordship. I got the instruction from the appellant. I'm going to withdraw. I'm withdrawing, Your Lordship. I have informed to the counsel for the because this now become infectious because there is another. This case was filed when the appeal was pending against the order of the chief judicial officer. So
you just simply withdraw.
yes. Now I'm just withdrawing, Lordship.
That revision, Lordship, it was listed yesterday, and it's the same person, the same party who has filed the criminal petition and
Challenging the same order.
No,
Yes,
Your Lordship.
challenging.
What happened, Your Lordship? What happened during the pendency of the? He has been convicted, Your Lordship. During the an appeal has been filed before the learned session judge. During the pendency of that appeal, they have settled the matter. They have settled the matter. So I raised the objection after the conviction. It cannot be settled. I cited also one authority, the order passed by the Honorable Supreme
No,
Court.
the challenge in the matter which Mr. P.T. Sangma filed.
Here is
It
they
is
want
against
for
conviction.
they want for quashing of everything, Your Lordship. After the matter has been settled, Your Lordship.
No, that is okay, but then challenges was this thing. They sought quashing of these conviction orders.
No.
No, Your Lordship. Of the FIR, the
proceeding.
proceeding.
This revision was filed before this thing final judgment
Lordship,
was
yes.
rendered at the trial.
Yes.
Lordship, yes.
So there will be no bar for the second revision, isn't it?
Lordship, yes.
Because this
Yes.
the
No bar. No bar.
first one is against this conviction.
Against the conviction.
Okay. Item 17 just is Mr. P.T. Sangma, learned counsel appearing for the petitioner on instruction submits that petitioner does not want to press this application and prays for withdrawal of the same. Give a paragraph on submission being made. This matter stands dismissed on withdrawal. This criminal petition stands dismissed on withdrawal. Yes.
Lordship. Apply, Lordship.
First place, Lordship.
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention item 13. Lordship, it may come after a week, Your Lordship. I have taken consent.
Well, they have informed us, no objection.
Item 30. Just say as requested by the learned counsel and list after 2 weeks. Yes.
Highly obliged.
Please, Your Lordship. I'd like to mention item number 6.
Yes.
Can you have this matter after 2 weeks, Your Lordship?
That come after 3 weeks, Your Lordship.
What is this matter?
This is conviction.
No pay parity.
Pay parity, Your
Pay
Lordship.
parity, Your Lordship. I am sorry. Pay parity, Your Lordship.
Item 6. Okay.
After 3 weeks, Your Lordship.
Okay. At the request made on behalf of the petitioner, this is matter after 3 weeks. At the request made on behalf of the petitioner and not objected to.
Lordship.
Learned AG appearing for the state respondents. List is matter after 3 weeks.
Similar
Yes.
pray for item 15, Your Lordship.
15 also let come after 3 weeks, Your Lordship. This is a POXO conviction, Your Lordship.
This is also after 3 weeks.
Lordship.
That is also the appellant. Here it will be appellant. And same order, otherwise. Yes.
Apply, Your Lordship.
May I please, Your Lordship. Lordship, I'm mentioning item number 3, Lordship. I pray that this matter may come up after 2 weeks, Lordship. Item 3, Lordship.
Lordship, this is regarding Akang matter. Well, they have filed a lot of defective petition. Then they have been keep on adjourning this matter.
That was the
One-
matter which was hard at certain.
Yes. It was heard at length.
And
quite
then we
number
are
of times.
confused about the facts.
Yes, and last time they keep on asking sometime to file a synopsis and then to file the written argument, to file additional affidavit.
They have filed it, but
They,
then
yes, and another day on the last occasion at the time of hearing, they said they will type some one order was they have not typed properly. There is a lot of defect in the petition. They have not enclosed. They have considered all the facts, and they only enclosed the impugn order. Only in impugn. That's why there was a lot of confusion.
what is
They are
to be
not
done?
able to assist the court properly.
What is to be done now?
Now, because they keep on adjourning, your lordship, that some order must be passed because they keep on adjourning on this on pretext of the other, like they will file the.
Yes. What is your objection? You have objection? No objection.
Because I'm for the private respondent because of this pending case.
The
Because
respondent has no objection.
no, because they are not affected because I'm the NOCMA now. Because this is regarding NOCMA. Because unnecessary pending of the case, I am not
You are
able
the
to.
NOCMA, isn't it?
Yes, I'm the NOCMA.
Then is there any interim order here?
No interim order, but the only plea is that because of the pendency of the case, because a lot of things going on in the field, because I cannot issue the NOCMA document. Also,
Why not? Nobody has passed in this thing.
yes, even then his people only, her people only objecting why you're issuing the notice when
Okay.
things were.
Miss So-and-so, Learned Counsel was appealing for the petitioner. Praise for adjournment of the matter by 2 weeks. Stuff. Mr. Piti Sangma, Learned Counsel, appealing with the respondent vehemently objects to the prayer of adjournment or the prayer for adjournment on the ground that the pendency of this matter is causing hindrance to the functioning of the. You are?
Yes, I'm the NOCMA.
You are the respondent of 4
Yes, private respondent for 4.
as a NOCMA.
If lordship may kindly say that I may just yeah, lordship.
This court is taking into consideration the nature of objection raised, comma, the prayer for adjournment is allowed. Stop. However, it's made clear that the pendency of this matter before this court shall not come in the way of a regular discharge of duties by the respondent number 4, but in his capacity as a NOCMA of which are acting.
NOCMA Ninkra.
NOCMA of such and such acting. Just check the thing from this.
Yes.
Stop.
Ninkra.
List after 2 weeks.
Lordship.
Obliged, Lordship.
Deeply obliged, my lord.
May I please, Your Lordship? I beg to mention item number 2. I'm praying for a week's time, Your Lordship.
Item number 2.
Yes, Your Lordship.
Why? What happened in this one?
My counsel is for some part hard matter is there today. Part hard matter is there today.
So there are many. There is a battery of lawyers here.
Yes, sir.
So if your seniority is not available, somebody else should be there. This is 2016 matter. This is what is this matter about, Mr.
Land
Thava?
acquisition matter.
Lordship, this is
Land acquisition matter.
land acquisition matter. You are praying for compensation.
Yes, Your
Your
Lordship.
coming is non-payment.
Yes, sir.
Yes.
We have no objection.
When?
After 2 week, Your Lordship.
Learned Miss So-and-so, Learned Counsel appearing for the petitioner. Praise for adjournment of the matter by 2 weeks. Mr. Thava, Learned GA appearing for the state respondent has no objection. Prayer allowed. List after 2 weeks.
Similar for a similar prayer for item number 16, Your Lordship.
It's a criminal appeal.
Yes,
Yes,
my
Your
lord.
Lordship.
No, you will not have no problem because he is in custody, isn't it?
Yes, Lordship.
So we'll be happy with adjournment.
Otherwise, he's serving his sentence.
This also as paid for by the appellant. Same order. Yes.
It's a pleasure.
Yes.
May it please your lordship. Lordship, I beg to make a mention for item number 5.
Is there any item left on the list?
Lordship, yesterday I've received information that the counsel for the petitioner her father expired, so she won't be able to.
There's no one for
No one, my lord. They have informed me yesterday, lordship.
So shall we record your submission or shall we just simply adjourn it?
Urgent, my lord.
Shall we say that you have said that
They have informed me, my lord. Yesterday.
you want this adjournment to be granted on that ground or you want
Lordship,
just a simple adjournment?
Lordship.
What?
A simple adjournment, my lord.
So that is better. You see, like that
Lordship.
statement, because now it should come from the other side. Somebody, you should make somebody stand from the other side, and because I cannot, not be proper.
Lordship.
Okay. Just as requested by the state respondents. This is matter of 2 weeks.
Deeply, your lordship.
Lordship, this is a
Yes.
joint request for item 4, Lordship.
Yes.
Item 4, Lordship.
You want to update it.
Lordship,
You want to upgrade it.
Lordship, we seeking time, Lordship.
You want to upgrade it. You do not want to upgrade it.
We want to, yes, Lordship.
You do not want to upgrade it. It is not a mention for upgrading.
Lordship, it's for adjournment for 2 weeks.
Yes.
You can come after 4 weeks, Lordship. It's no urgency.
Is it a joint prayer?
Lordship.
Yes, Your Lordship, joint prayer, Your Lordship.
On the joint request made with the parties. This is matter after 2 weeks. Is it that this matter has any connection with the judgment passed today in the division bench?
Some bearing, Lordship.
So you have to take into consideration that part of it.
After 4 weeks, Lord.
Hmm?
After 4 weeks.
After 4 weeks.
After 4 weeks, Lordship.
4 weeks is too long, isn't it?
It can come after 2 weeks, Lordship. Then
4 weeks. Make it 4 weeks. On the joint request, huh?
Obliged.
Yes.
Daily cause list, item number 1.
Yes.
Very please, Your Lordship. Your Lordship, this is a revision we have filed basically against the order of the Session Judge and the Chief Judicial Magistrate. What had happened in case of 354, in case of molestation case, there's an allegation in the FIR. And apart from that, through all the evidence, Your Lordship will see that trial has gone on the basis of leading questions only. In the chief, all the leading have you done, is this correct to all the leading questions you can make out, Your Lordship.
What happens if it is allowed to go?
No,
See,
that will
say supposing if evidence is recorded on the basis of leading evidence, can the appellate court correct it?
Yes, yes. Supreme Court has held. Therefore, I have.
What does it say? What the law says?
It is there. So for that moment, if Your Lordship is pleased to turn there in. This is
What the law
1994 Supreme Court.
See, we are at the stage of motion. You do
Yes.
may not have to give it in
May not
just tell us
require,
what
but
the law
still, Your Lordship, that because here's a.
What is this?
This is a. I have just printed out. In fact, the book is there. I can give the book. I'm so sorry. Just actually, I have just printed out. This is year 1993.
Yes.
Yes. Here it's
See that proposition. If it is speaks about that proposition, that the leading question should not be put. That we understand. But then if it is allowed.
So therefore, that have been turned to acquittal. Supreme Court has turned down all the convictions and made into acquittal.
On the basis of this thing.
Yes.
Where is that? Where is that?
That is from the middle. Your Lordship will see section 142 that therein the adverse party is entitled to put leading question, but section.
Give us a proper thing. It's very difficult for reading here.
I know. I'll give the proper. Means
their citations are there. You get.
Yes, it is there. It is there. I shall give that. I shall give that. There are files.
So that is one thing. That is one ground. That is leading questions were allowed to be put.
And on that basis, the conviction has come. And apart from that, what happened? The language is a problem. The complainant later it admits after a conviction it comes that a compromise has been arrived at by the complainant not to pursue the matter.
Couldn't follow. Please repeat the submission again.
Complainant arrived with an agreement with the accused after the CGM's order, got conviction done. After that, when the case is pending before the session court, they have arrived at a compromise saying that is a total misunderstanding of the language. She doesn't understand Hindi. That being the reason that she had filed a case. Your Lordship, and that is page, if Your Lordship, that is
this compromise was attained after the conviction was recorded.
Yes, that is what a peculiar thing. So,
and then in your first appeal before the session court.
Did
you bring
that was brought but not looked into. That was the case.
What is the finding of the
since it was convicted, therefore they didn't look into that. And the paragraph page 68, if Your Lordship is pleased to see that part. Paragraph 68, Your Lordship. Page 68, I'm sorry. Your Lordship. And whereas middle portion, page 68. Lordship got that, Mary.
Yes.
Yes. And whereas
this is a compromise date.
Compromise. And whereas the complainant during the pendency of the case have voluntarily with her own free will have decided to compromise, for which she has decided to settle the matter amicably.
Can you take into consideration this compromise at this stage? What is the law? In some other matter, Mr. Shulai had.
Yes, I got that point.
And he said after conviction cannot.
After conviction cannot be. But Miss, I am bringing.
We'll just issue notice. We'll just see. This is a revision. We'll
revision.
The records.
But actually, your Lordship, what happened? He is already 4 months 3 days. Is a 1 year rigorous conviction has been given, and he is an employee of CRPF.
Did not obtain this thing. Did not file any application under 389 before the trial court. Before the appellate court or trial court, wherever it is, you did not file any application.
No, they didn't file. Here we have filed. Here we have filed. Here we have filed a miscase.
You have filed a miscase, but then here now for this court will have to go by merits then.
So that being the reason, your Lordship, at least if you can, that sentence can be suspended and allow him to be on bail.
Should have filed an application before the court, which sentence, if there is law for the.
Yes, they should have done.
If you do not avail it, who can help you?
They didn't avail it.
That is why this court is asking you whether you have filed an application.
No, they didn't file it.
Before the same court.
No, they didn't file it.
For suspension of sentence, you did
Yes,
not do.
They didn't file it.
What is the conviction you said?
1 year. 1 year rigorous imprisonment and 10,000 fine.
And how long he has been in custody?
For 4 months, 3 days now, as on today. And he is a constable, CRPF constable. For 20 years service he has surrendered.
During the trial, he was on bail.
On bail. After conviction of the session judge on 11/7, 24, he is still there in there.
After conviction, he was taken. Lordship, let this revision be admitted, Lordship, and regarding the bail, Lordship, suspension of the sentence. So,
For the
I
timing,
will have
maybe
objection. We have objection.
You have objection. What is your objection?
Lordship, because he is the offence, he is a CRPF personnel who is supposed to look after the law and order and safety of the people, but he is committing this kind of offences, Lordship, and he was in his uniform when the offence occurred.
So he's a protector of law, basically.
Yes,
And then
he's not supposed to commit these kind of offences, Lordship. Let it be admitted, the revision, and the paper book may be prepared, and we'll take it up and dispose it at the earliest.
paperwork will be needed here.
I don't think, because the evidence I have given, everything is here.
No, but then since
Of
it is
course,
there are two courts, you do one thing, Mr. Mahanto.
Yes, yes.
We'll give you this thing, expeditious hearing. You prepare the paperwork, by the next day we will take it up for hearing.
Yes,
Instead of deciding piecemeal.
Yes, I'll do that.
See, you did a mistake. Basically, you should have approached
Should have
the trial
applied.
court for
Yes.
this.
No, it came much later to me. That's why.
And that compromise also, it was not done during the pendency. It was done only this year, March this year.
Anyway, heard Mr. S.P. Mahanto, Learned Senior Counsel, assisted by Mr. Lindo. Issue notice, returnable in 2 weeks. This is from which court?
This is Tura, who is
Returnable 2 weeks. Mr. Rich Karni, Learned Additional Senior PP, has entered appearance on behalf of all the respondents.
Yes.
only.
Only one respondent.
Yes. Call for the records.
Only one respondent.
Call for the records. This matter immediately after arrival of the, immediately on the receipt of the trial court record.
Lordship, if the compromise relying on the compromise deed, then if that's the case, they'll have to make the complainant also a party, Lordship. In my
Let us see.
understanding.
This is not upon this argument. Let us see
No,
Yes.
whether compromise because the basis or not, whether at a revisional stage we can take compromise into cognizance compromise or not. That these are all questions which will be open to you. You just see,
Lordship.
just see, verify this.
Yes.
You prepare this paperwork then in the meanwhile.
as soon as the record is, I'll just prepare. Immediate, I'll do it.
You do it then, and then we'll hear the matter.
Yes, we can dispose of
You
findings.
should have filed this application before the test. There would not have been any hassle.
Item number 2.
In fact, the whole record, so to speak, it has gone in heavy. As your lordship knows that sometimes the communication gap is there with them. So many things are there. Anyway, your lordship, it's much.
Please, Your Lordship.
Yes.
Your Lordship, this is an application of restoration in which
Restoration of?
this case, Your Lordship, was dismissed by this Honorable Court on the 28th of August, Your Lordship, for non-prosecution by
There is a delay. It pays there is a
delay,
application
yes,
for-
Your Lordship, 44 days.
And then
And then, Your Lordship, the reason there was a delay because the counsel, the previous counsel for the applicant, Your Lordship, he has not even informed him that his matter was dismissed by the court. He came to know much later, and that's why, Your Lordship, there is a delay of 44 days.
yes, Mr. Dr. Mojiga,
Lots of permits to file a small reply, man. I'll file a
about
small
condemnation.
on condonation.
You want to file objection?
The several dates, no one appeared.
No, not several dates, Your Lordship, 2 consecutive dates. What happened was that, Your Lordship, when the matter was
Now
taken
you are
up,
seeking restoration of what? I mean,
restoration
petition.
of, no, not the review, because Your Lordship, what happened when they filed the review application, Your Lordship,
There is a
was,
review. You are seeking.
uh,
Just a minute. This is not a restoration of writ petition or
No,
what?
no, not writ petition, Your Lordship, review petition. But at the time when the review was filed, a condonation application was also filed, Your Lordship. The dismissal was on the condonation application. 2 consecutive dates, the counsel for
Definitely,
the
dismissal will be condonation. Once condonation is dismissed, it means the review was not taken.
yeah,
into consideration.
review was never
Let them-
taken up, Your
since
Lordship.
there are
Yes.
these things, we'll just let this objection be filed. Yes,
Yes.
hard miss. This condonation application. This is case number 11 of 2024. Okay. And Miss P.S. Nambri.
Yes, no, yes, Your Lordship.
And the counsel appearing for the petitioner. Issue notice. You are appearing for all the respondents, Dr. Majika.
Your Lordship, there's
Except for number 7.
respondent.
1 till 6.
7 you have to take
Your
steps.
Lordship will take steps for respondent number 7.
Okay. Dr. Majika, along with so and so, appears for the respondent number 126. Stop. The petitioner shall take steps for service of notice upon respondent number 7 within 2 days.
2 days, Your Lordship, tomorrow and the after is a holiday. PM.
2 days means working days.
Okay.
Okay.
Yes, Your Lordship.
So make it within 3 days. When you say 2 days, that means that is always working day. Not
yes,
taking
Your Lordship. Yes.
Make it 3
Apologize,
days.
Your Lordship.
So, this is matter after 2 weeks. Yes.
Highly obliged, Your Lordship.
Hearing item number 3.
Yes, Mr.
An
Gopal.
application praying for, my lord, interim bail, my lord, in criminal writ petition.
Yes, Dr. Majika, any objection?
I'll not object because he duly surrendered,
That
my
is
lord.
what is expected of you.
My lord. He surrendered duly, my lord.
Yes,
in
definitely.
possession of the last order. My lord, the similar conditions may kindly put. My lord.
Where is that? Where is that earlier order?
The order is here.
And then for how long you want? This time is
I've been
application
told
for
15 days, my lord, they have this ritual. My lord, may grant it for 20 days, my lord, because there is some time in travel also.
how many? You want 20 days?
20 days, my lord, because I've been told that they have rituals for on the 15th after the cremation is done. Generally, we have for 13 days, but
This miss case number 4 of 2024.
4 of 2024.
What, Mr. KCH Gautam, learned counsel for the applicant, and also Dr. Majika, assisted by so and so for the respondents, appearing for the respondents. Yes, appearing for all the respondents. All the respondents. So this is an application seeking the release of the petitioner on bail for a period of 20 days to enable him to perform his father's last rites, who is stated to be who has not say who has passed away. Do not say who has passed away on what is the date? 11/11/2024. Stop. It appears that the present application is a second such application. As the applicant had on earlier occasion also filed Miss case. You just see this number from here, huh? Miss case number. Okay. With a similar prayer for release on temporary bail on the ground that his father, within bracket you say, now deceased, was seriously ill. Stop. This court, White order dated 21/10/2024, allowed the earlier application. Do not say granted. Do not say allowed. Have granted the prayer made in the earlier occasion by allowing the applicant to go on bail for 10 days. On certain conditions specified in the said order. Stop. It is submitted that the applicant has complied with the conditions stipulated in the earlier order, and after completion of period of bail, has returned back to the Pura jail. Dr. Majiga Lanet, DSGI, appearing for the respondent, also acknowledged the fact that on the earlier occasion the applicant did not violate any of the conditions, and on such basis on such premises, give a do not say basis, realizing the urgency of the situation, did not raise any strong objection against the prayer made in this present application. However, the learned DSI has submitted that the conditions which are stipulated on the earlier occasions may also be imposed if in the event the applicant is allowed to be released on temporary bail as prayed for in this application. Give a paragraph. Stop. Considering the fact that the father of the petitioner has passed away, and petitioner being the son has to perform many rituals and that on earlier occasion and that the petitioner had not violated any of the conditions of bail on his earlier release from a, it is deemed appropriate to allow the petitioner to be released on bail for a period of 20 days on the following conditions. We stipulate the same conditions. You do one thing on the following conditions, then you give here only one thing you have to correct is
10 will become 20.
Is 10 days, you have to make it 20 days.
In para 5 also, the last second last para also.
Yes. Okay, from here, still last part. It's all right. Such type of application should not be opposed.
I'm not opposed.
It's nice to see the fairness of a council.
I'm so glad.
The court appreciates that.
Thank you, sir.
Obliged.
Especially this man has not defaulted.
That is reasonable. Had he defaulted, well,
Yes, and then what to do about this appeal will be taken after 3 weeks. This appeal.
After that only.
so go to February now.
What is the earlier order first?
But 20 days he comes back, Melody, the winter vacation is almost.
Okay, just you say. We'll just simply adjourn it after 3 weeks.
Vale.
Yes, on the request of the parties. List is met after 3 weeks. The main appeal. You don't. You go first. You type out this order first, so that it is made ready. Because tomorrow these things, and you can tell Sriti to be here for other things. You just type this first. Make sure no mistake is there. If anything is wrong, just see the earlier order and then tell me correct. Yes. Obliged. Yes.
Daily cause list hearing item number 8.
Yes.
My lord, this was sent for mediation also, my lord. It did not work out.
Failed.
It failed, my lord. Failed twice. No, my lord.
Lawyers do not give proper advice that is expected.
My lord, I from my end have tried my level best. My lord, the problem here is.
It's on the lighter side anyway.
Absolutely, Lord. So the problem here is because the allegation made against me is that, my lord, I am into gambling and all. I am bankrupt, and one of the fact remains that if I am bankrupt, I'm not in a position to pay a huge amount of alimony. My lord, today, my lord, I'll seek some accommodation, my lord, because
the party could pay you for engaging you. No,
my lord, the party's the brother is there, my lord, not the man. Well, my fees is very reasonable.
Brother is
not
not ready to take the burden of the demand
part of the ancestral property is already taken, and that also is lost in gambling. Lordship will see the pleadings. In the pleadings also she herself has mentioned. But there is one flat in Calcutta which we wanted to give to her, but when it did not work out. So, my lord, give me some time, my lord. Otherwise, Lordship has heard this matter to some extent. Some technical questions are there. We'll have to place some judgment.
Yes, as requested by the petitioner and not objected to as requested by Mr. K.C.S. Gautam, learned counsel for the petitioner, and not objected to by Mr. Ahmed, learned counsel appearing for the respondent. Is this matter after
2 weeks only.
2 weeks?
2 weeks.
This matter after 2 weeks. Yes.
Item number 12.
This is a petition under 482 my lord, challenging the summoning of a director of a company under the Drugs and Cosmetics Act. And basically the primary contention here is that my lord, the concept of vicarious liability, whether directors are liable or not. My lord, in fact, Lordship has passed one judgment, not in the case of Drugs and Cosmetics, but some other one. So my lord, where Lordship has discussed this particular aspect also. If you want to.
Lordship, I'm praying
About the
for,
vicarious liability.
Vicarious liability.
Lordship, I'm praying for accommodation in this matter, Your Lordship.
And what this court said, that they are
well, actually the law itself is
jointly and severally liable, or what?
They cannot be liable, my lord, unless my lord, there is a specific allegation that I am, my lord, in the.
That is
the day-to-day
probably
affairs.
even the Supreme Court has repeated
Absolutely, my
that.
lord,
Probably.
absolutely, again and
That
again.
until and unless there is a specific personal
Exactly.
imputation in this thing,
And
cannot.
personally, the person is involved, especially in drugs and cosmetics, the manufacturer of drugs and cosmetics.
Probably there is a recent decision in this regard. Also.
Well, there are
Just-
so
just
many of
try-
them.
just
my lord.
try.
I placed a compilation.
Yes.
my lord, I'll place
For
it
how
somewhere.
long accommodation?
2 weeks, Your Lordship.
Yes.
Well, I have no objection.
Yes. The Miss So and so. Achha, on prayer of the learned counsel for the respondents seeking accommodation, which is not objected to by the learned counsel for the petitioner, comma, this is matter after 2 weeks.
Yes, Your Lordship.
Obliged.
Highly obliged, Your Lordship.
Item number 14.